The changeover doesn't quite have Formula One efficiency, does it? No, those pit stops in Formula One are blink of an eye these days. It's barely 1 second. Okay, our third and final case of the day, 23-30514, First Baptist Church of Iowa, Louisiana. The Church Mutual Insurance Company, Mr. Bourgeois. I pronounced that right, correct?
Bourgeois.
Bourgeois. Okay, you're up.
Thank you, Your Honors. Travis Bourgeois and Candace Chauvin on behalf of Church Mutual Insurance Company.
Oh, I got that wrong. I'm sorry. You represent Church Mutual.
Church Mutual.
Go right ahead.
We're here before you today on an insurance dispute. You've read the briefs, you know the facts, but I just wanted to provide a quick brief of how I'm going to approach this issue today. We have the adjustment of a hurricane claim by Church Mutual. We don't have any competing estimates on the other side.
Can I stop you right there? My head scratching is over the fact that I don't know what adjustment means, and neither brief seems to provide a definition of adjustment, what it is, what it consists of, any authority that helpfully tries to define it. So I guess I've got three interrelated questions. So how do we define adjustment? Is there an objective standard for what adjustment is? And I guess finally, when is an adjustment complete? Can you start off there?
Sure. Judge Willett, that's an excellent question. Your question arises because the trial court, Judge Kane, in this instance, found that Church Mutual did not do an adjustment of the claim. This is a claim brought by an insured against an insurance company for supposedly failing to adjust the claim. It's not our burden to show what an adjustment is, and I can't tell you an objective standard for an adjustment, but I can point you to the testimony of Mr. Fink and Mr. Coubant in the record. It starts at 829 and it continues. It's well documented in the brief. Judge Kane wants to know what did you do? And they explain how they adjusted the claim, what Mr. Fink, a licensed Louisiana adjuster, understands adjustment of a claim to be, and what Mr. Coubant, on behalf of Church Mutual, understands an adjustment to be.
There were many estimates created. There were
Correct.
many reports created.
Correct.
But how do we know that all those estimates and reports taken together constitute an adjustment?
Because Mr. Fink and Mr. Coubant said that, and there's no competing evidence on the other side to say that Church Mutual did not do an adjustment of this claim.
Here's question 4.
I didn't even get to 2, but I'll...
No. I think you were addressing 1, 2, and 3. Well, so question 4 is, if you can't give a standard definition of what an adjustment is, and if there's no objective guidepost as to whether one happened, then isn't the district court's finding that one did not happen a fact finding that we would review for clear error only?
I say no, and this is why I say no, because there's no evidence of it. It's something that Judge Kane, with due respect to Judge Kane, has created in your head, because I'll point you to page 836.
Let me point you back to the question. What is our standard of review as to whether or not there was an adjustment?
The standard of review would be a factual finding.
So it's clear error.
It's clear error, but then you revert back to whether there's any factual evidence in the record to support the finding that there is no adjustment.
Well, that would be,
and there is not.
Whether there was a clear error or not.
Yes.
Okay.
Correct. But pointing you back to, there is an objective, or at least from a Louisiana licensed adjuster, page 836, where our counsel directly asked Mr. Fink to cut to the chase. How do you adjust the claim? And he responds there. In a small claim, we might, as an adjuster, be able to show up and write an estimate right there. But in a large, complex commercial claim, we invoke the assistance of experts like the engineer in this case to come in and really look at us and tell us what the scope is, and then we make a determination from that. What we do after that is come up with an estimate, send it to the insured, and get them to put some kind of agreement or tell us why it's wrong spin on that, and then we pay. Number 3 is absent here. There's no competing estimate by the church whatsoever. What we have here is filing of a suit before any estimate by the church is ever offered. The report it relied on at trial comes from January or February 2023, years after the loss. Trial is in May of 23, and their estimate continues to fluctuate. It fluctuates before trial, the first, probably and most important issue in this appeal, in the form of pricing. They come up on the morning of trial and say, oh, we just have a new estimate, but we've adjusted the prices. What does that do in a matter of 3 months? It jacks the prices up by $20,000. Now remember, we're already 3.5 years out. What did Church Mutual's adjuster do? He said, I have to apply, pursuant to the policy provisions, the prices as of the date of loss. So his estimate is dated from September of 20. The opposing estimate, as I said, is from January of 2023. This is the vast gulf of difference that, with great respect, Judge Kane had a problem wrapping his head around and saying there was no adjustment. Why such a big difference? Pricing. Pricing is number 1. And the estimate continued to change during trial. They dropped an entire line of claim for economic losses and an expert to whom we had imposed a Daubert challenge. Mr. Chambers, their adjuster, admitted he had made mistakes during the trial. They only produced receipts for their supposedly undisputed proofs of loss during trial. And Judge Kane shows in his judgment that he actually adjusts Mr. Chambers' estimate in some $16,000. So there's just no undisputed proof of loss. And why is that important? That is central to the key of whether we were reasonable in going to trial on this claim and whether we can be in bad faith. And our position is we absolutely cannot. But the first and most important position, in backtracking to that, is pricing. How did this problem happen? Judge Kane found the policy provision ambiguous regarding how you pay a loss, the valuation and loss payment provision. There's a replacement cost provision and an actual cost provision. Both of them say you are to assess damage at replacement costs or actual cash value, quote, as of the time of loss or damage, close quote. That language is repeated 3 times in the contract. It has to have some meaning. Judge Kane found it was ambiguous. That is our first legal error asserted in this case. It's the reason why this case went to trial. It's the reason why there's 2 disputes in the estimate, and it affects everything. It affects the damage award, it affects the penalty award, it affects the attorney's fees, and quite frankly, it shows why we were reasonable. We raised this issue in our pretrial order on page 135 of the record, and throughout trial, we took a position that the policy controls. That's error number 1. With respect to the absence of bad faith, the first error we have asserted is that there is no written proof of loss as required by Louisiana Revised Statute 22-1892 by the insured to even begin the triggering of the 30-day time limit to pay for the bad faith penalties to attach. When you look at the wording of the statute, section B says, and I quote, payment within 30 days after receipt of such satisfactory written proofs and demands, therefore, close quote. This is referring to a written proof of loss. There was no written proof of loss by the time the suit was filed. The only time one was given was in February prior to the trial, but it's not undisputed. It's not satisfactory. And the cases are legion. We've cited them. Reed, Louisiana, Bag, Gardner, Hedrick, and Darby that says an insurer is entitled to dispute a disputed proof of loss, even if it is written, without being subject to penalties. This is a penal statute which must be given strict construction, and it is the plaintiff's burden to show that we have been arbitrary and capricious. The pricing alone shows why we were reasonable. The various elements included, and the plaintiff's expert report shows why we were reasonable in disputing. Inclusion of cost to rework the entire facade, payments on a building which was dilapidated and the pastor admitted he wanted to tear down and had no use, inflated electrical costs, cost to re-repair a parsonage that had already been repaired. Quite simply, the whole point of this trial was to truly determine which damages were caused by the storm, the proper pricing, and what was due. There is no bad faith damages here. There's no proof from the plaintiff's side that we acted arbitrarily and capriciously. The logs they offer show that we showed up within 10 days. We did an estimate. We retained an adjuster. We retained an engineer, and we made payments completely throughout trial, which total some $393,000. We made an initial advance payment of $100,000 without any proof of loss at all. The only thing that was submitted was a repair for the parsonage roof of some $9,000, which we immediately approved and was subsumed within this $100,000 loss. So this is quite serious here. You have a penal statute in Louisiana which must be strictly construed and narrowly applied. We have no evidence on the plaintiff's side of arbitrary and capricious behavior, but we have full evidence on our side, even in some of the plaintiff's exhibits, the claims log, the letters that were done of a continuing adjustment of claim without any competing proof of loss on the other side. That in a nutshell is one of the biggest errors in this trial.
Just a quick record question. Is there anything in the record that indicates that any of the HVAC units were damaged in the storm?
There is, Judge Willett, there is an indication on the record that one of the HVAC units was affected, and Osteen included that in his estimate. The Chamber's report includes an estimate to repair each and every HVAC unit. They didn't even retain anyone to inspect the HVAC units to even tell them if it was done. And you bring to mind an excellent point. I believe it's Defendant's Exhibit 18. And it was a list we asked Mr. Osteen to compile showing how Chambers adjusted the claim and how he adjusted the claim, and to show which elements were different there and why he thought he was correct. We offered this to the trial court. Again, this is a bench trial, not a jury trial, to help and show why Church Mutual believed that its $339,000 was the reasonable choice. I think that exhibit alone shows the reasonableness of Church Mutual's position. And it will also assist the court, if you need assistance, in showing which elements Chambers included at excessive prices and for reasons which were not clear to Osteen.
But you were, all right, so you're comparing Osteen and Chambers, and you said something about how they both adjusted the claim. Osteen didn't adjust the claim. He's not an adjuster.
He didn't adjust the claim. He was retained by an adjuster, Mike Fink.
But isn't there a difference?
Mr. Fink says there is no difference. This is how an adjustment is done. Yes.
The district court said there was a difference.
It did. And we believe that ruling is without factual support in the record.
Except that Osteen wasn't an adjuster, so therefore could not do an adjustment.
But Fink is the adjuster, and Fink says the way I perform my adjustments is I reach out to experts such as engineers who might have expertise that I don't, especially in a large loss, to give me advice. He adopts, reviews that estimate, and incorporates it into his adjustment of the claim. The second part is he gives it to the insured to see if they have any competing estimate. And there is nothing here. Now, understandably, the church was frustrated in their slow progress, but this frustration was caused by their choice to hire a strategic, can't remember their exact name, as a public adjuster, and they spent 7 or 8 months here essentially doing nothing, not reporting to their own client, not reporting to us, and then come up with $1 million estimate, which was not even introduced at trial. So the church fires them and hires an attorney and eventually gets around to giving us an estimate in February before the May trial.
Okay.
I'll reserve the rest for the book.
Thank you, Mr. Bourgeois. We'll see you back on rebuttal. Let me try this one. So you?
Well, Judge, it's a difficult one, and no one ever gets it right. But it's Soileau.
Really?
Yes.
Say it one more time.
I'm sorry?
Say it one more time.
Soileau, sort of like S-W-A-L-L-O-W, but the emphasis is toward the end. If you're a wine drinker and you know Pinot Noir, O-I is Wa in French, and Bordeaux, E-A-U is O, so you get a Soileau.
Okay.
But I've tried that about a dozen times or so, and it never helps anyone.
Okay. We'll restore your 23 seconds that I've stolen.
That's quite all right.
All right, take it away.
May it please the court, Rudie Soileau, speaking for Iowa First Baptist. I'm not sure where to start, but I'm going to start with this. You were just told that Mr. Fink agrees that what Mr. Osteen did was an adjustment. That's not accurate. At 869 of this record, he said that the estimate that Mr. Osteen prepared was not an adjustment. I repeat, Mr. Fink, the chief adjuster, said that what Fink did was not an adjustment.
Let me pose to you. Maybe you're getting there.
I'm ready.
Same
Let's do it.
questions I asked Mr. Bourgeois. How should we define it? And is there an objective standard as to what an adjustment is, and when is an adjustment complete? When is it baked?
Very well. I know of no separate guideline or objective standard, but I do know this, Judge. I do know this. Wesley Ellis, Mike Fink, Cole House, John Coupont, Natasha Lorick, and Patrick McEnany. Those are 6 people who are all licensed claims adjusters, licensed to do an adjustment of a claim in Louisiana. They were all assigned to the Iowa First Baptist claim on behalf of Church Mutual. Some of them visited the site. None of them adjusted the claim. Not one of those 6 licensed claims adjusters adjusted this claim. Now, if we're going to try to define an adjustment, we have to start with someone who is a licensed adjuster. And what we do know is that the state of Louisiana does have guidelines and a requirement to be licensed. And so when the district court asked if these people, Mr. Osteen, for example, was a licensed adjuster, to his credit, he said no. And there's a citation. Are you claims adjuster? Are you authorized to do that? Mr. Osteen said no. Now, I've heard about the engineers. I've heard about Mr. Osteen helping. We brought all these people in. We got there quick. But at some point, someone has to adjust this claim. And this claim was never adjusted. That's why the district court said at page 17 of its trial opinion, there is no evidence in this record that this claim was ever adjusted. Now, Mr. Bourgeois, I don't believe was at the trial. I was. He talked about the chamber's adjustment that came in 2023, and he said that was the only one, and he had to wait until Chambers in 2023. But he just acknowledged that the church went out and hired a public adjusting company. Strategic Claims is the name he was looking for, because this church immediately reported this loss. They cooperated. They allowed multiple inspections. They took steps on their own, to try to secure the buildings, protect the buildings. When they couldn't make any progress with Church Mutual, they hired a public adjusting company. The public adjusters came to the church in March of 2021, not 2023, 21. And those public adjusters met with Mike Fink and other representatives from Church Mutual and presented a loss of approximately $1 million. The Chamber's estimate was not the first one. The strategic claims loss was the first one. I need to pause myself a little bit. Really, the important thing that's getting lost here is that Louisiana law, our insurance code in Title 22, says in 1973, literally, expressly, the insurer has an affirmative duty. And the problem in this case with the actions by Church Mutual is Church Mutual is constantly questioning, criticizing, complaining about what we did. Did we give them a satisfactory written proof of loss? Did we do this? Did we do that? And Church Mutual, Mr. Bourgeois gets last word. Church Mutual clearly has an affirmative obligation to adjust the claim. That's first.
But what are the church's obligations? I mean, did you give an estimate for the roof or for the furnishings or for the HVAC? I mean, all those kinds of things. And I'm talking contemporaneously. The storm happens in what, September of 20?
The first storm hit on August 27 of 2020.
Was that Laura or Delta?
That was Laura. Delta was October 9, 2020. And actually in May of 21, we had a very significant rain event.
But we're talking about, I guess, so Laura, right?
Right.
But along these times, did the church submit anything other than the roof estimate, I guess, for the parsonage?
Not in 2020, no, not in 2020. But
was the church required to do that?
Absolutely not. Absolutely not. In fact, this court just addressed that in the Sugartown case. A January 5, 2024 decision. I have the site here, if I can find it in my book. But this court in Sugartown just recognized, citing Louisiana BAG, which is a Louisiana Supreme Court case, and of course we are dealing with Louisiana law, that the requirement for a proof of loss is a flexible requirement. The cases in Louisiana after Hurricanes Katrina and Rita, and now Laura and Ida, are very clear that there is no written form, no specific thing that the insured has to do to satisfy this idea of a written proof of loss. That's manufactured. That's not in Louisiana law. They did what they needed to do, Your Honor. They made the church available. They provided information. And yes, by 2021, March of 2021, the strategic claims estimate of the loss, the adjustment by strategic claims, was in the hands of Church Mutual. Now, you know, coming out of the pandemic, 2 named storms and some other tough times in our area of the state, having that meeting in March of 21 is pretty timely. And it gave the information that Church Mutual needed. And certainly, you know, they had the Chamber's adjustment. The Chamber's adjustment, which the district court said was the only credible adjustment by a licensed adjuster in this record. And the district court was right about that. The district court was right.
Is that the one that was done the day before the lawsuit was filed? Or?
Right around the time of the lawsuit. It was in preparation for many weeks, but that is that one. They got that. They got sued. That's a demand. They got the Chamber's adjustment. That's a written proof. 30 days passed and nothing happened. Many, many times over. We're 1,285 days right now since Laura struck. And Church Mutual still says it's adjusting this claim. And that's just not right. That's not the way this works. If you will look, and I'll have to find it to give you
Do you
the
agree that that this, whether an adjustment occurred or was completed, was a finding of fact by the district court?
Absolutely. Absolutely. All of that is finding of fact.
What do you do? Let's talk to another subject that counsel opposite said was a primary issue in the case, and that is this pricing issue.
Pricing issue.
We've
Okay.
got competing pricing of fall of 2020 and then 2023.
That's correct.
What do you do with the language in the policy that says the replacement cost is as of the time of loss or damage?
I think the policy taken as a whole is ambiguous.
What do you do with that language, though? Seems clear as a bell to me.
That particular sentence seems clear as a bell, but it's
Where's the ambiguity?
the ambiguity is that the insured purchased and paid for a replacement policy.
As of the time of the loss or damage.
I don't read it that way when I read the entire policy.
Well, but it doesn't say at the time of the repairs.
No, it doesn't. But the interpretation that Church Mutual suggests is that if they withhold the money and sit on the money and we don't make repairs and time passes, it's to their benefit.
Well, but that may go to bad faith. But it doesn't change the term of the policy as to when the measurement.
It does not change. I recognize that language, and if we excise that statement, then you can read that one statement and say it seems clear. But it does not seem clear, or it does not seem correct against the backdrop of the contract as a whole. And I believe you have to look at the purpose of the contract, the cause, as we would say in Louisiana, for the contract. This was a replacement cost. I think it was ambiguous. And then two things, if I may.
But how can you can read them consistently, can you not? It's the replacement cost as of the time of the loss or damage.
No, I don't, because you can't replace at the time of the loss. That's why they didn't use August 27. They used September. We couldn't replace it in September. No, I don't think you can read that consistently.
But that's certainly what the district court found also.
That it was ambiguous.
Right, that there was ambiguity because
That's right.
you couldn't read them consistently.
I agree with the cause of the contract. Two things. This is the second, I mentioned the Sugartown case. This is the second case. In Sugartown versus Church Mutual, Judge Kane also found the contract ambiguous. That was an issue on appeal. If you look at footnote 22 on page 21 of the original brief filed by Church Mutual, so that's page 21, footnote 22, Church Mutual explains that yes, this issue of ambiguity, this issue or question of contract interpretation was before the court in Sugartown. And it notes that because the Sugartown appeal was still pending, it was a live issue. Church Mutual says in footnote 22, it was entitled to make this argument that it was not ambiguous and that the date evaluation, as you suggested, Judge Wilson, would be on August 27 of 2020. Sugartown is no longer up on appeal. That case is decided, and the case was affirmed. And I do believe that the decision in Sugartown should control here. It's the same policy language, the same issue. Sugartown did not have an RCV, that is a replacement cost clause. So I think our position is stronger. But I do think that...
Your position is that Sugartown basically binds this panel for determining that the insurance policy here is ambiguous?
I've been doing this for a while, but never say a panel's bound. But I do think it's controlling. I do think that this is what I want to say, Judge. That issue was presented in Sugartown and decided in Sugartown, and it should come out the same way here.
Same policy.
Same policy language,
But you
not
said-
the same policy.
Same policy language, including the replacement cost and the time of loss or damage.
When I say the same policy language, I'm talking about the language that the court cited to me. Yes, sir. Yes, sir. Second thing, I said I had two things. Second thing I want to say on this, if this court thinks that we're limited to August 27 on the cost, on the valuation, then I would ask and suggest that the case go back to the district court and we can rerun the numbers for August 27, 2020, and the court can have an opportunity to decide if the increased cost of materials that has occurred over time is a consequential damage, because it is. The fact that they withheld the money, didn't pay, didn't act on their affirmative duty to adjust the claim, they were going to reduce it back to August 27, 2020, then increased cost when we go to repair it is a consequential damage. And under 1973, recoverable with a penalty provision there. And the net effect of all of this is going to, frankly, be that the award's going to go up. Because, yeah, if we go down to the lower pricing and we back out the penalties and back out the attorney fee, and then we go to 1973, and if the court finds that they were in bad faith, then it's a tripling with a fee, and it's going to go up. The net effect will be to go up. But so if this panel decides that, well, we're going to limit you to August 27, 2020, then it should go back down for a determination of consequential damages for the correct value and for consequential damages. And my client doesn't want that. I don't want that. We want to fix our church. We want to have a nursery. We want to have a fellowship hall. But candidly, I think that would be the correct response. I need to come back and say that if you will look at Plaintiff's Exhibit 28, which is at the record 2428 and following, this is a September 2021, September 2021 Ingle Martin report. Ingle Martin was hired by Church Mutual to handle this claim. And beginning in December of 2020, and this goes back to the timeliness, in December of 2020, Mike Fink is signing reports for Ingle Martin sent to Church Mutual. It says the total loss is $630,000. Here's the deductible. Here's what we've paid. And then it says, in December of 2020, quote, net outstanding, and the amount is $358,074.52. Over the subsequent 9 months, beginning in December of 2020 and going forward, all the way till September of 2021, which is Plaintiff's Exhibit 28 that I cited a moment ago, that same net outstanding is there, and it's never paid.
Is that in excess of the 100,000 they sent?
Oh, absolutely.
In other words, that's net. That's the net amount above.
That's what he's saying is outstanding due. That's correct. Above by then they had paid more than 100,000, but he is still telling them that's Mike Fink, lead adjuster, licensed adjuster, never adjusted the claim, but a licensed adjuster is telling Church Mutual for the IOA claim that he's handling for Engel Martin, retained by Church Mutual, that they owe $358,000. This fallacy that at some point this will all come finished. I mean, we're here today, 1,285 days after Hurricane Laura struck, and we still don't have a final adjustment from them. The law says they have to pay the undisputed amount. And when Mike Fink says that's outstanding and they don't pay it, they're in bad faith. And there's one other thing, you know, it may not seem like a lot to some of the cases that I understand, you know, the cases that come through this court. Church Mutual told, we talk about what did the church do, what did it have to do? The church had volunteers coming from everywhere to help. Church Mutual said, we can't have you bringing in volunteers to tear out the sheetrock, clean up all of this. You have to use a remediation company. So they hired ServPro. Church Mutual works with ServPro. We get a $60,000 bill from ServPro. Mike Fink says to the church, pay it. They pay it, $60,000. Church Mutual turns around and depreciates that cost. You can't depreciate remediation. It's work that's happened. I mean, you wouldn't depreciate it if you could because it's happened and it's been paid. So they sent a check. They allocated in a check $48,000 to Iowa First Baptist. Iowa First Baptist was out $60,000 because Church Mutual said, hire ServPro. We send in the $60,000, we get $48,000 from them. Mr. Coubont, who was the corporate representative at trial, he said, yeah, right, we shouldn't have done that. We owe you that $12,000. Well, I'm standing here today still looking for that $12,000. They haven't paid that either. And at trial, Mr. Coubont admitted that they owe it. They shouldn't have done that. At some point, the evidence piles up. So, is $12,000 enough to prove bad faith? I know my folks back in Iowa, Louisiana, that small congregation, that small town, would appreciate that money. They would appreciate that money. And Mr. Coubont says it's due, and he hasn't paid it. Hasn't paid it till today. And they have an obligation to continue to adjust the claim. So they say, where's the proof? Where did Iowa prove that we're owed money? Even when they say they owe the money, they still haven't paid it. And Mr. Coubont, by the way, and I know I'm rambling some and I apologize, but Mr. Coubont, by the way, their corporate representative at trial, who testified, also acknowledged that the claim was not adjusted. Mr. Coubont said if he could go back and do one thing different, this is at 10:08 of the record, if he could do one thing different, he would have one of the Church Mutual adjusters adjust the claim. He acknowledged it's not been adjusted. And Judge used the word bake. I mean, I was at trial. I kept hearing about, well, we sent this engineer and that engineer and this construction consultant. And I felt like, yeah, at some point, you got all that, but someone has to bring all those ingredients together and adjust the claim. And I called it bake the cake. If you have sugar and flour and eggs and milk in your kitchen, you still don't have a cake. Louisiana law, 1973, says there has to be an adjustment. And Church Mutual never baked the cake.
Is that enough for bad faith? In other words, if we disagree on the pricing and we say, well, it should be 2020 pricing, not 2023 pricing, is there still oh, do we still affirm the bad faith finding?
Absolutely. P-28 and all the reports that between December of 2020 and September of 2021 that keep telling Church Mutual you owe them $358,000. They have to pay the undisputed amount. They don't get to wait until, Mr. Chambers said, well, I understood a tree fell in the parsonage and it was a limb, so we need to adjust that down. That's honesty. That's fine tuning. That's fine. Church Mutual does not, under Louisiana law, get to wait until all that is done. They have to pay the undisputed amount. When they turned the claim over to Engel Martin and said, you handle it, Mike Fink, and Mike Fink writes them 7 times saying you owe $358,000, they have to pay it. Their own adjuster is telling them that based on the information he has. So that's bad faith.
It sounds like you're equating adjustment with payment. Are you? No, but in these cases, we've seen so many of them, you go in and you see that the sheetrock is damaged and the roof is leaked, and so you can do an initial adjustment for those damages. You may come back later when you bring an engineer and find out you've got to pull some joists and restructure the roof. Okay, that's new damage, and now an additional adjustment or a supplemental adjustment, and then you're going to owe that money as well. But what you can't do is withhold the first amount that you know is due, waiting for more information. So payment, when you have enough information to know there is an undisputed amount due, you pay that. You don't get to negotiate and hold back the money in the hopes that you can settle the case for less. You have to pay the undisputed amount, and that's what they did not do. Did I answer your question? I'm sorry. Well, you actually raised another one. In your example, you had an ongoing process, and you're talking about payment, the obligation to pay the first proof of loss, and yet continue looking at the issues. So isn't that exactly what happened here without the payment?
No, because Mr. Fink's telling them in December of 2020, we owe another $358,000. That has to be paid. And the $12,000, okay, they made a mistake. They depreciated a ServPro invoice. Should they have done that? No. Is that bad faith? I don't know. People make mistakes. But when they don't pay it by the time of trial or at trial or after trial or by the time of appeal, that's moving into bad faith. Yes, I think that's bad faith. And the courts have been clear that if the insurer is in bad faith, they owe penalties on the entire amount.
Okay, Mr. Soileau, thank you very much.
Thank you, judges. I appreciate the time.
Mr. Bourgeois, you have 5 minutes on rebuttal. So what about the ServPro invoice for water mitigation?
Okay, the ServPro invoice. Mr. Fink testified that he did approve the ServPro invoice, Mr. Steen, and it is included in other parts of his estimate. He explains in his testimony as reconstruction or something like that. But look at Mr. Chambers' estimate. He double charges for the whole ServPro estimate, which was 127 or something, when half of that, over like 57, the church is saying, we're not paying that. We disagree with that. Even Judge Kane is saying, yeah, that's overcharging. We're not going there. So we have a double charging on one side, and we have a payment on the other side, although it might not say ServPro invoice, and I do believe it was... It was Defense Exhibit 12, the one that I was referring to, and it's an element in there. Okay, to respond to the argument, my esteemed counsel was up here talking about all of these things that Church Mutual did, and to me, it's just an adjustment. It's in conformity with Mr. Fink's explanation of an adjustment. And after all, we've been sued. It is the plaintiff's burden, if they want to say that an adjustment never happened, to call somebody to testify that an adjustment never happened. If you look at the questions as they occur in the transcript, these are questions that are coming from the trial court, I think, pointing out a hole in the plaintiff's case. The defense evidence is there was an adjustment and it did happen. He talks over and over about the Ingle Martin reports that mention the $630,000 figure. Mr. Fink and Mr. Coubant both testified on cross-examination that that's a reserves figure. That's not what we actually owe. Even from the first report, Mr. Fink wrote and he explained, this is a preliminary estimate. This is a pass-through. We need an expert. And in his October 22nd, 20 report, Plaintiff's Exhibit 20, he gets that expert report. And he says, our net recommendation is $271,617.81, of which you've already paid $100,000. So there's your estimate right there. This $600,000 has been a smokescreen. With respect to the Sugartown ruling, first of all, that is a pure curiam, unpublished ruling. I do not think it is binding on this panel.
It may not be binding, but is it persuasive? Does it address this policy?
It would have been persuasive had they ruled on it, but they did not. And I will quote you from the Sugartown. We need not decide whether the district court erred in its evidentiary ruling about the insurance policy. Even assuming it did, CM fails to show that allowing counsel's questioning about the ACV provision would likely have swayed the jury's verdict. Did not pass on the issue. The other, getting back to you, Judge Wilson, you hinted on a very important question here when you asked the church what it did. When you look at all these cases and when you look at the statute about bad faith, it's responding to a proof of loss. That proof of loss comes from the insured because the insured knows what its damages are. The insurance company comes and it takes a look, and if it has no other information, all it can do is point out the damages it sees. And that's what happened here, and we paid the damages we saw. So it invariably becomes the question, how can we know about damages that we don't know about because you have not revealed them to us and be subject to bad faith penalties under a penal statute? The difference here is a viewing initially of 271,000, which eventually goes up to 383, versus coming back with $1 million estimate saying this is what you owe, and you should have known it the first time you stepped on our property, which is the trial court ruling here. As of September 8th, 2020, you should have known undisputably that you owed $1 million. Therefore, you are in bad faith. I have 4 seconds, so I'll just wait.
Make the most of it.
We ask the court to reverse the ruling of the district court below. We don't think there is any need to remand, as the opposing counsel suggests. Of course, that's within your ambit, but we ask for a full reversal of plaintiff's failure to meet their case in chief.
Thank you, Mr. Bourgeois. We appreciate the arguments of both sides, and that will be it for today. And we'll be back at 1 p.m. tomorrow afternoon.